Yes, Your Honor.
Is that explanation set out anywhere in your affidavit? The explanation you gave this court for that discrepancy?
Yes, this is understood.
No, my question is the explanation you're now offering 1.5 years later, is it said, show me the paragraph of your affidavit that explains the discrepancy?
It was not required.
It was not required. But for the record, is it given in your affidavit, that explanation?
Not given because not
Good.
required.
It's not given. This summary gives the consultants who are attending to the patient. Can you see that part of Exhibit 3?
I do, yes.
It begins with yourself. Who are the other doctors?
Your Honor, if you allow me to explain.
You can look at it.
I know it.
I haven't asked the question for you to explain. You can only answer questions I ask.
I know the names on the list, but I can look
at them. The names
them,
given there.
Yes, I can look at them, but I know them.
You know them?
All of them, yes.
Is the maker of this document one of the doctors who are indicated as attending to this patient?
No.
No.
Do you need an explanation?
So we don't have the primary document, and we have a summary made by a person who did not attend to the patient.
Not correct.
Not correct. Is Dr. Sarita, just for the record, indicated as one of the doctors in this summary who are attending to this patient?
She is not a consultant.
My question is she indicated as one of the doctors who are attending to the patient? From the list given at the top, is Dr. Sarita one of them?
Your Honor, I must explain what this list of consultants mean to the audience here.
We are not interested in that. The question is she indicated? Either she is, and Dr. Wade, quickly, if you answer the question, the more we kick about the bush, unfortunately, the longer time it will take.
But I can't allow you, sir, to proceed on a misunderstanding.
My Lord, the witness has no...
Excuse me, Dr.
Yes.
You came here to give evidence.
Yes,
you answered questions as put to you by counsel.
Okay.
Without any.
But if Your Honor,
just answer the questions as put to you. If you don't know, you say you don't know. Then we proceed.
And that's how the law works, Dr. Gikonyo, just for the record.
Thank you. I understand now.
So is Dr. Sarita indicated in this document?
Should you find that there's a need for clarification?
Yes.
They will ask you to clarify.
All right.
Yes.
Go on.
So, Dr. Gikonyo, is Dr. Sarita, the maker of this summary, indicated as one of the physicians that were attending to the patient, known as RG? On the face of it, is she indicated in the list of those doctors?
Not as a consultant.
Is she indicated in any other way?
As the one who prepared the document. Yes.
That's not my question. Just wait. Is she indicated as attending to the patient in any medical capacity? The maker of this document.
The people taking care of the patient are not listed.
I thought they are listed here, sir, about 6 of them.
Those are the consultants. There are other doctors in the system, medical officers, intensive care doctors, and other people. And as I mentioned earlier, we are a teaching hospital.
Is there any material you have placed in your affidavit to show those other doctors and the fact that they were attending to the patient?
No.
Good. In fact, on the document before the court, we have no way of knowing who else other than the 6 given that attended to the patient.
Only by asking the parts of the doc.
No, we are talking on the document side.
Not on the document side.
Good. Let's go to the bottom of that document. Bottom left. That document has a computer timestamp at the bottom left, correct? bottom left, below prepared by Dr. Sarita.
That is right. 2011, 24, 12:40.
12:40 p.m.
Yeah.
So what is the date and time of this document's preparation as per that timestamp? It is prepared on the 20th of November 2024 at 12:40 p.m. Correct or incorrect?
Right, that's correct.
Now let's go to the opposite side of the page, bottom right.
Yeah.
What is the date and time given? The date you confirm?
20 November 24, 12:35, 19.
12:35. You have to agree those are two different timestamps. Correct or incorrect?
That's correct.
You must agree, sir, that it is not possible for this document to have been prepared at two different times as it purports to say.
I won't understand why the computer would do that. I would have to check on the computer data.
Unfortunately, sir, you have to agree with me that on the face of it, this is a discrepancy as to the time when this document was prepared. It has two timelines. Which one do we take?
I do not know.
Good. Patient and prior history of the conditions described there.
None at all. But if
None at all.
If
Good.
required, Your Honor, it's
None at
available.
all.
It's available. I have it on me here today.
Unfortunately, it's you who testified on affidavit or note, sir, that he has passed history. So you have to agree with me then, in the absence of that material on the record, this is just an allegation. We have no way, based on your affidavit, to confirm that the patient described there had this prior history.
You have no way, but if you are interested in knowing, it can be provided.
Doctor, you say you did a number of tests on this patient.
Yes, Your Honor.
Including an echocardiogram.
Yes, Your Honor.
2D. One is called 12 LED and the other one 2D, right?
Yeah.
You must agree with me that that machine for echocardiogram generates a report and a graph. Correct or incorrect?
Of course. Yes, it does.
Yes, it does. Have you in this affidavit attached that graph that the machine generates to show that the patient has the conditions described in the summary?
No, it's not. Available if required.
No. My question is, have you attached to the affidavit the report that the echocardiogram machine generates?
Definitely not.
Good. Have you attached the report that the other machine automatically generates?
Not attached, but exists.
Fine. Have you attached the images that were supposedly taken of this patient?
If I thought they would be useful for this court, I would have attached them. I thought it was not necessary to attach them, but they are available if required.
But you would agree with me that the images and the graphs and the reports would be the primary document evidencing the illness, correct or incorrect?
Correct.
Therefore, if that is correct, you must agree with me that this summary, in the absence of those images and those graphs and those reports, cannot be the evidence that patient RG had the conditions described in your affidavit.
Unfortunately, I would not agree with you.
Fair enough. You say he also took some blood tests.
Yes, Your Honor.
Have you attached the laboratory report of those blood tests to this affidavit?
If you are required, we can. They are
No,
available.
Doctor, my question
They
is,
are not attached.
have you attached
Deliberately
the
not.
laboratory report of the alleged blood tests?
Deliberately not. Available if required.
So again, based on your affidavit, you have to agree. We have no way of knowing whether there were blood tests or what were the results of any such blood tests.
I disagree. We have a way of knowing. You can ask me, I can produce them.
Page 3 or 4 talks of hemoglobin, platelets, and blood chemistry and other things. Correct or incorrect? Either it does or it doesn't, Dr. Arif.
It does.
Do we have in your affidavit the primary document, that is the laboratory report for all these tests?
Available if required.
No, my question is, do we have it in your affidavit?
Definitely not. They are not there.
Definitely not.
Yes.
In page 404, there is some information there about follow-ups. Have you produced before this court any document on that follow-up?
Has not been requested.
The question is, have you annexed it, sir?
No.
You have not annexed it. So again, I put it to you, there is no material before this court to confirm there was any follow-up. Dr. Gikonyo, in summary, you have admitted you have no material before court to show the prior history of the patient. You have confirmed there is no material before the court to evidence his medical condition when you supposedly attended to him. And there is also now no material of the follow-up. Is it not because this gentleman was in your hospital to hide away from the Senate? He was not sick. I put it to you.
Let me laugh a little bit first.
Trust me, I too have been laughing about it.
Sir, Your Honor, I must apologize. I must apologize. I must apologize, Your Honor, for that. I must apologize, Your Honor. But honestly, sir, if the question arises as to those documents that have been raised, if they are available, and if you are looking for justice and honesty, you can ask me to provide them. And it takes 2 seconds. They are here.
Yes, you may have them, but they are not on the record, sir.
You can have them.
Unfortunately, the law does not permit you, Dr. at this belated stage, to even refer to them because they should have been put on the affidavit. But to my summing up questions, your affidavit alludes to some media coverage
Yes, Your Honor.
of his alleged illness.
Yes, Your Honor.
Did you give yourself a press conference on this illness?
Yes, Your Honor, on demand from the press.
On demand from the press?
Yes.
Dr. Gikonyo, is it standard medical practice for doctors to give press conferences as to their patient's illness?
It depends on the sensitivity of the issue.
The question, sir, is it standard medical practice for doctors
Yes, when it's
to
required.
call press conferences?
No, sir, we don't call for press conferences.
Okay.
Press comes to us.
When you are giving this press conference, the case before the Senate was proceeding, correct or incorrect?
Most likely so.
You found time to give a press conference, but you didn't find time to go and tell the Senate.
Oh, no.
Okay.
In what capacity would I go to the Senate?
Good. Wouldn't the Senate, where the proceedings were going on, sir, have been the natural forum for you or any of your colleagues to go and tell Senate that the witness cannot come because he's been admitted in hospital?
I'm not sure if access to the Senate is available to every common person like me.
That's all from me. I will yield the floor to Mr. Mukele Melod to wrap up the cross-exam.
There is a serious allegation in the form of a question raised by Dr. Thionkulu that Dr. Gikonyo was hiding the first petition. That was posed, and I'm not sure that Dr. Gikonyo was given the opportunity to respond.
Why don't you respond when you respond?
Just for the record, the witness answered and he said his answer was to laugh.
We'll deal with it.
The process is to deal with it.
We'll deal with it, yes. Thank you.
My Lord, to the issue. Senior Counsel Dr. Giancol was covered quite a bit of ground. I will only have about 3 or 4 questions for this witness. I don't think I have much to add. Good morning, Dr.
Good morning, sir.
My name is Edwin Mukele. I represent the third and fourth respondents. I've been permitted by Senior Counsel, Professor Ojeda, to ask 1 or 2 questions on behalf of the Senate.
Thank you, sir.
Now, I had your last comment to be that you are not sure, and this goes to Dr. Giancolo's very last statement, you're not sure whether you have access to the Senate. That's what I heard you say.
Yes, I said so, sir.
Now, Dr. Gikonyo, the affidavit that you presented before court is sworn on the 28th of April, 2026.
That's correct.
That's correct. Do you recall when the first petitioner was impeached?
Not the exact date, but I believe the same day that he came to hospital.
The same day that he came into hospital. Would that be the 17th of October 2024?
Most likely so, sir.
Most likely. This is about, we then receive your affidavit in court about 1.5 years.
That is correct.
After he has been impeached.
That's correct.
Now, going back to your evidence, and I'll be very brief, Madam. When asked a question on whether the documents you presented would have been presented to the Senate, your answer was, the request has come now. That is what I had you to answer to one of Dr. Kiako's questions.
Yes, that's why I'm here today.
The request has come now.
That's why I'm here today, sir.
So the request, Dr. Gikonyo, to file the affidavit and the attached documents has come now. That is what you said, yes?
Yes, I mean, yes.
From whom did you receive the request?
From the petitioner.
You received the request from the petition.
Yes.
Do you recall, do you know when the petitioner first filed the petition? Might you know?
No, I don't. And I'm not interested.
You're giving evidence and you're not interested
In
the context of a petition in which you have no interest. Is that what you're telling the court?
Yes, that I'm here purely on a medical issue, not on a court issue.
That is startling, Dr. Ali, I must say. It means, in my view, you probably don't understand the reason you're here. But I will go on. You have also, and this is my last question, mine, very brief. You have also confirmed that you do not know whether the affidavit and the documents attached were before the Senate. Do you have any information on that?
Not at all.
You don't have any information on that.
And I agree with you, sometimes I really don't know why I'm here. Because my understanding is I'm here to answer medical questions about the petitioner in hospital.
So,
about law things and court and Senate,
so
I am ignorant.
So, Dr. Gikonyo. Dr. Gikonyo.
Yes, Your Honor.
You cannot tell the court, from what I understood, whether the affidavit and the documents presented today, sorry, the affidavit sworn by yourself on the 28th of April, were before the Senate at the time of the impeachment proceeding.
I wouldn't know. And
you didn't know.
Your
That's
Honor,
okay.
I have no interest in those matters.
That's okay. That's okay. We understand that you do not know why you're here. Madam, those have been my very brief questions on behalf of the Senate. I beg to.
Thank you.
Thank you.
Dr. Gikonyo?
My Lord, we had Dr. Kamoto to us. Just two questions, then the witness can be re-examined. If you permit him, please.
My Lord, there was no affidavit filed by Dr. Kamoto, and you have given directions before the commencement of this process.
Let Dr. Kamoto speak for himself. Dr. Kamoto, did you file any affidavit?
Yes, my Lord, my lady.
Did you file any affidavit?
We have put our responses. We are doing a joint approach to this matter. We have a joint approach to this matter, and that's why you find, my Lord, that not every one of us makes submissions or presentations or revocation.
I think while you could be correct, if I allow you, then there's no basis why I do not allow the other side, because they could also just hang on that point. I think for clarity or purpose, I don't think it's fair to allow you to proceed.
Very well. We are most right.
My Lord, I'll proceed with the re-examination of Dr. Gikonyo. Very quickly, Dr. Gikonyo, I'll refer you to paragraph 11 of your affidavit.
Yes, Your Honor.
On the reason why you filed the affidavit. Could you come clear or clarify why you saw this affidavit, referring to paragraph 11?
Your Honor, that is the way I understood it, until I was made to understand that I had to understand other things of the Senate and other court matters. Because as far as I'm concerned, Your Honor, that paragraph summarizes why that I make this affidavit in my capacity as a medical expert, not a legal expert, in adult cardiology, to assist this honorable court in establishing that the first petitioner was duly admitted to hospital on the date in question, underwent treatment. That was my understanding.
And you had earlier confirmed that the contents of your affidavit were true,
Completely.
to the best of your knowledge.
Completely. And
Thank
I took a note on that.
Just to clarify a few issues that have propped up during cross-examination, and I will go back to paragraph 4 of your affidavit, and I'll be direct this time around because it cropped up. Is there any admission issues in paragraph 4?
None at all.
Thank you. So at 3 p.m. on 17th of October 2024, what exactly happened?
At around 3 p.m. is the word. Approximately is the word.
Yes.
If you want to know the exact time, it was 3:25. I have it.
What happened?
At around that time is when the petitioner arrived in hospital.
Thank you.
We took him in. We started the normal thing that we do for history taking his weight, blood pressure, and such. At that time, if you allow me to explain, is the time we start now the admission process.
Thank you.
And admission is a process, not an instant. And as we are doing those things, the accountants asking who is going to pay for this, blah, blah. And when they are ready, then they fix on the computer, this man is now admitted.
So when was he admitted?
According to our document here, 4:18 p.m. That is when the actual documentation of admissions were completed. These are technical details of timing and writing. Before that time, we are still seeing the client. We are doing the necessary things, but he's technically not admitted because the accountants have not allowed us to do that.
Thank you. I'll refer you to page 1 of 4 of the discharge summary. And on the top, the patient name is Mr. RG. Who is RG?
You know, Your Honor, if you come to hospital and you are an ordinary citizen, we put your full names and all your other names. There are clients, we don't put names on record.
My Lord, we still object. That evidence is extrinsic to the record. It is inadmissible. And my good colleague here knows that question is also impermissible.
The question was actually raised in cross-examination, and what we are seeking is a clarification on who RG is.
And Your Honor, I have said, our practice in a hospital to protect privacy, because this document go out to hospitals. The malaria parasite is positive, blah, blah, it's for so and so. We use codes.
Can you just
who is
ask him who RG is?
RG is the Honorable Rigathi Gachagua.
Okay, is there any other identification information in that document? Have a look. Is there any other identification information with respect to that, without necessarily reading it out?
There's a mobile telephone number also.
Thank you. Would you confirm whether there is any discrepancy between the affidavit and DKG3, the discharge summary?
Not at all.
Thank you. And lastly, is DKRG, what document is DKRG? Because there's been an allegation of a medical report. What is DKRG?
It's a discharge summary.
It's a discharge summary.
It's not a medical report. A medical report gives details that may not necessarily be required by this court. But if required, Your Honor, it's available.
And in your discharge summary, you were confirming what you deponed to in paragraph 11 on the purpose of the affidavit.
Absolutely, Your Honor.
Which is admission, discharge, and treatment.
Absolutely.
Thank you, Your Honor. That's all.
Just one very brief question, Dr. Gikonyo. It was put to you by Dr. Thionkulu that you admitted the petitioner, His Excellency Rigathi Gachagua, to hide him, suggesting he wasn't sick. And I think you responded by laughing. Now that you have finished laughing, will you please answer the question? Was Rigathi Gachagua sick or not sick? Why are you hiding him in your hospital? Please answer. It is a serious question.
I must say I laugh because I thought it was not a serious question, because maybe it is not common sense. But however, the answer is yes, he was sick. We admitted him. We have data that's available to any medical person. We have medical reports. We have traces of his ECG, his echoes, everything, lab data that's available and available on demand by this court.
And apart from the documents, Dr. Gikonyo, you are here as a doctor, head doctor who was treating him.
Your Honor, that's why you called me, to answer those questions.
That's
I've
right.
answered the affirmative. I was the one who was treating him with my team. He was sick. We have data. We have provided an affidavit. If there's any further questions, we will provide it.
That's all, my lord. Your Lordship.
Thank you, Dr. for coming to clarify those issues. You may now take your seat.
My lord, can Dr. Gikonyo be released as a witness?
I would say that he can take his seat.
Okay.
He can be here or he can go home.
Oh, okay. That is the only clarification. I don't think you'll be going home, you'll be going back to college.
There's water. There's water. There's water. Is that your water?
Yeah.
Yes, my lords and my lady. Again, we are now in the proper business of the submissions, and I am ready to proceed subject to any other direction that you may want.
What is the kind of directions that you people will be seeking in relation to the procedure?
My lord, if it works for the court, we would want to have the remaining part of the day for us as the respondents, try and push and possibly conclude our submissions. We also hope that if time allows, we could then have any responses so that the matter is closed today. But I think what we'll be asking for specifically is about, we will not go beyond 8 hours on the outer side.
We're talking about 8 hours and we're talking about concluding today.
Well, you know, you have previously sat up about 10 p.m., but I wanted to get your direction so that we also know how to budget and plan as to when we'll be ending, so that we know which testimonies you take and whether or not you want to have us progress with the submissions this morning.
Thank you, Mr. Gumbo. Before we give directions, we probably want to know how many of you will be addressing the court and what directions do you require with respect to the cross-examination that has just happened? Will you follow that up by making oral submissions so that we don't have to take written?
So, my lord, we will, in the course of making our oral submissions, be also submitting on what has transpired during the cross-examination. So that need not bring any complication. The respondents will deal with issues in the course of highlighting their written submission.
So that is Mr. Gumbo and
So, my lady, on behalf of the National Assembly, we will have 4 of us making our submissions. We do not expect to go beyond 2 hours.
yes, and that is for the National Assembly.
That's for the National Assembly.
Yes, Your Lordship, my lords, on behalf of Senate, I will lead the team and will be on point. We'll be assisted by 2 other counsel on other questions. Not more than 2 hours. I think I should take not more than 2.5 hours. I'm normally very brief.
My Lord, on behalf of Professor Kidure Kindiki, we also need 2 hours. We'll be sharing the time with the team that I lead.
On behalf of the Attorney General, I wish to confirm that we do not wish to make any further submissions, as we believe that our submissions were clear and nothing we have had since we made them has changed that position.
Your Lordship, if I may, on behalf of the 9th respondent, we require about 45 minutes. My Lord, for the 10th respondent, we'll just do 1 hour.
Okay.
On the part of the commission, we'll take about 8 minutes.
Which commission?
The ABC. The 16th response.
Lord, may I suggest that perhaps we start with the IBC, which is taking 20 minutes, and then we come to the parties who wish to take longer. And also wonder why my learned friend, Dr. Tiankulu, would require the same amount of time as the primary respondents. He is really an interested
I
party.
think those submissions were being made on the light of the knowledge that I divided by half. Yeah, I will certainly will not give you 2 hours. I'll not give you 2 hours. I'll not give you 2.5 hours. But will give you sufficient time for you to make coherent submissions in this matter.
Our only concern is parity of arms. That side took about 10 hours. 10 hours. So we'll be taking less, even if you add all the times that they took. Yeah, it's even when you subtract the half, they still took 10 hours.
They did not, but we'll give you sufficient time.
My Lord, for the record, for the speaker, my Lord, Milimo, my Lord will be taking not more than 30 minutes.
That's 15, that's good. So can we have the person who set the pace, 10 minutes, IEBC?
If it may please you, my Lord. My name is Kibe Mungai. I appear with Mr. Kamwaro and Mr. Peter Koira for the 10th to 41st petitioners. We made our submissions on our petition last Thursday. My Lord, we are here for the simple reason that the following day, on Friday, the Constitutional Court of South Africa rendered a decision with regard to an issue of presidential impeachment that directly deals with part of the issues that was substantially raised on behalf of the first petitioner and by the 10th to 41st petitioners. A judgment that is directly relevant in this matter. Being proactive, yesterday, the 12th of May, we filed supplementary submissions to bring which parties to bring that issue with a view that the supplementary submissions that we did, the court may certify them as duly filed so that they become part of the record of our submissions. And today, so that to enable the other side to respond, to be able to seek directions of the court on how we should be progressed based on that issue. We make this request for the simple reason that the Supreme Court, in the case of Sonko, that has been cited severally, indicated that the advocates and all the parties and the court have a responsibility to ensure that cases are decided on the basis of all relevant matters of law and fact and the best research that is possible. So we are under our duty, and we have done something direct, proactively, to certify that duty, that this is a decision that needs to be considered by this court. And the right procedure, if I may be asked, is that I would be requesting that within 30 minutes, I can formally, before they start, because it is a matter they would have a right to respond to summarize what are the issues and brief reasons why that decision should be incorporated and the sense in which it should be understood by this court as part of the petitioner's submissions. I believe in particular the first petitioner, whom Mr. Ochier said a lot of things about that issue of the Senate and the special committee, would have an interest in that particular matter. So may I request for directions on that issue? It is already filed, the decision is also filed, so that all that would be required would be to hear what would be the best way to proceed before the respondents have started. I believe, in view of the proceedings that have taken place, the petitioners have just closed their case for today. Only that my learned colleague, Professor Mugai, had made submissions on behalf of the client Attorney General. So that's all my question.
My lords, we became aware of this decision as soon as it was issued, and this is largely due to my younger learned friend who circulated it, and for which I thank him. It's a very weighted decision from the Constitutional Court of South Africa. It will be our submission. It is totally irrelevant. What I would propose we do, just like my learned friend Mr. Kibe Mungai has done, he has filed his own submissions on it. I would beseech my lord to open the same path to anybody who wants to submit on it, and we leave it at that. We do not wish further time be expended on this is the court, this is the judgment of a foreign court about foreign law. So it should not detain us, and we should proceed as my lord has said.
That's a sensible suggestion on our side. And I also think that the court can save time for rejoinder by allowing most of the petitioners to make their rejoinder in writing that way, and then the wish to conclude today could be achieved.
Mr. Kibe, look.
It's just that it is irresistible for the first petitioner to join issues, Professor Gidu Muigai, that this decision is utterly irrelevant.
It is?
He said, he told this court that the decision is utterly irrelevant.
I thought you were confirming that.
My concern is that there cannot be a more relevant decision on the attempt to avoid a committee of parliament to do the investigation, and on the jurisdiction of the court to question actions and decisions and resolutions of parliament this decision answers to those two issues. But if everybody gets leave of this court to put in written admissions on that point, then I'm in agreement with senior counsel, Professor Gideon. Thank you.
I knew, my lords, one day before we retire, my learned friend and I will agree on something.
Thank you very much. I think we have more or less agreed that we treat Mr. Kibe's submissions on that issue. We allow parties for submissions on that issue. And between now and then, and the time we retire, to write our ruling, if you have an authority, just file it. Just file it, we'll consider it.
Only that we shall say something about it during the rejoinder.
All right, that is okay. Yes, IBC.
Melon, we have Ms. Joy and Mr. Nura, I think the president called.
We will particularly take note of time.
Your Lordship could give me a second to catch my breath. The house will get from the back of the court to the front. It pleases my lords, my lady. My name is Nura Abdul Kadir. I appear alongside Ms. Joy, Ms. Faith Kiende, Mr. Derek Asala, and I also hold brief for Mr. Mahar Somani for the 16th respondent to the IEBC. And together with these oral submissions that I will make, the 16th respondent also relies on the submissions they filed on the 25th of October 2024, 27th of October 2024, and the replying affidavit sworn by the then CEO, Mr. Marjan Hussein Marjan, sworn on the 25th, my lord, of October 2024. We'll be relying on those documents, my lord. We will briefly highlight on a single issue, my lord and my lady. And that issue is the IBC's involvement under Article 149 of the Constitution regarding vacancy of the office of the Deputy President. And the main question that we will be asking is whether the Constitution contemplates any role by the IBC in the filling of that vacancy. My Lord, Article 49 identifies two actors expressly. That is the President and the National Assembly. Therefore, the question that arises for this court's determination is whether, beyond those two expressly identified individuals, those two expressly identified actors, does the Constitution intend any additional role for any other actor, but for purposes of this submission, the IEBC? My Lord, it is our humble submission that that particular article is deliberately narrow and precise by design. It provides two constitutional actors and two constitutional functions. First, the President, who nominates a person within 14 days. Second, the National Assembly. So on a plain reading, my Lord, of that article, the Constitution does not introduce any third actor, any intermediary, institution, or any additional clearance mechanism where IEBC would play any particular role. And my Lord, in answering this question, and because these submissions have been made severally before this honorable court, is what would have been or what could be the intentions of the drafters of the Constitution. And in asking ourselves this question, my Lord, we interrogated the harmonized draft and the Bomas draft 2004. Under Article 168 of the Bomas draft 2004, my Lord, the process was expressly confined to the President and Parliament. And while this process was a bit more complex than what we have in our present Constitution, involving both houses of Parliament, it still made no mention of the IEBC. When we move closer to the current Constitution that we have in the harmonized draft at Article 170, it is more similar to our Article 149. Again, there was absolutely no mention of any role played by the Electoral Commission at any point. Therefore, both drafts reveal that the drafters of the Constitution, sometimes we belabor too much on what the drafters intended. It could be easier to just reach out to Professor Gilmiga and ask him what he intended. But it is clear from those two drafts that there was no intention to involve the Electoral Commission. Therefore, we ask ourselves, where could the qualms and the quarrel by the petitioner have arisen against the IEBC? And that would fall on one article of the Constitution. That is Article 148, the qualifications of a deputy president. If you look at the qualifications of a deputy president under Article 148, the Constitution references you to the qualifications of a president in 137, which further references you to the qualifications of a member of parliament, which is Article 99. My Lord, it is our submission that the petitioners proceed from an assumption that the IEBC must therefore undertake a formal verification or a clearance exercise as though the filling of a vacancy under Article 145 were an electoral process, which we humbly submit that it was not. My Lord, it is our humble submission that if there is any role that is not expressly stated or implied under Article 149, it would be to the two actors who have been mentioned in that article. That would be the President and the National Assembly, to satisfy themselves that the nominee meets the constitutional requirements of that office. My Lord, in that context, and seemingly out of abundance of caution, that we submit that the President sought factual information from the IEBC. And the IEBC merely responded with information that was within its custody, whether or not an individual is within the voter register. My Lord, we submit that up to that point, up to the point that the IEBC provided that information, it was not under any constitutional obligation or duty under Article 149. It simply provided information that it possessed. Now, my Lord, the other qualm that the petitioner seemed to have is whether the information issued by the IEBC was improperly provided by a commission which was not properly constituted. My Lord, I humbly submit that this particular issue has been heavily argued before courts, and there's several case law that demonstrate the roles played by the IEBC, either by the Secretariat or the Commission, or the Secretariat and the Commission. And we humbly submit one of those very important authorities, which can be found in our digest, is the presidential petition of 2022, E005, Raila Amolo Odinga and others versus the IEBC. My Lord, we submit that in that case, three distinct roles came out clearly. So the IEBC possesses a role where the Constitution references, or where the legislation references the Commission. It could mean the Commission and the Secretariat, as was elaborated in that case, with the issue of verification and tallying. So a reference to the Commission could mean the Commission and the Secretariat. The instruction is to the Commission, but the action is to be taken out or to be handled by the Secretariat. And that can be found on paragraph 46 of that decision. And the second role would be that if legislation or the Constitution references the Commission, it quite simply means the chairperson and the commissioners. And that role is reserved strictly for the chairperson and the commissioner. And the decision went on to note that there are such roles that can be taken or handled by the Secretariat, such as this one that we submit. My Lord, from that precedent, two principles clearly emerge from this binding authority. Number one, the Commission acts institutionally, not through personal involvement of the commissioners, in every function. It doesn't act through the commissioners in every single function. And that the Secretariat performs the day-to-day administrative and technical functions. So, my Lord and my Lady, the act that is complained about involves no deliberate decision-making by the Commission. It do not require any decision-making by the Commission. It requires no policy formulation, no exercise of constitutional discretion. It was purely factual and database driven, involving retrieval of information held in the voter register, verification of that information, that indeed the individual whom you sought information from is a registered voter,